Hi, this video is about separation of church and state and how it got started. Back in September 23rd, 1800, Thomas Jefferson wrote to Benjamin Rush that he has committed himself to not allow any denomination to achieve the, quote, establishment of a particular form of Christianity. Now, this meant that he did not want to allow any particular religion to be the major religion of the country. He wanted to allow different religions in there, and everybody was equal, in other words. November 7th, 1801, Danbury Baptist to Thomas Jefferson. They were concerned that, quote, free exercise of religion appeared in the First Amendment. To them, it implied the government had the power to regulate religious expression. They believed that the freedom of religion was a God-granted, unalienable right, and that the government should be powerless to restrict religious activities unless those activities cause someone to work ill to his neighbor. Jefferson agreed with them and assured them that their freedom of religion was an inalienable right and would not be meddled with by the government. Jefferson's letter to Danbury Baptist Association, January 1st, 1802. Jefferson, the First Amendment has erected a wall of separation between church and state to ensure that the government would never interfere with religious activity. The clear meaning of the First Amendment for over 150 years was it prohibited establishing a single national denomination. House Judiciary Committee report on March 27, 1854. Had the Founding Fathers during the Revolution a suspicion of any attempt to war against Christianity, that revolution would have been strangled in its cradle at the time of the adoption of the Constitution and its amendments. The universal sentiment was that Christianity should be encouraged, but not to any one sect or denomination. Now, this is from the same Judiciary Committee, and I quote, "In this age there is no substitute for Christianity. That was the religion of the founders of the Republic, and they expect it to remain the religion of their descendants." Now, this is from 2 months later. "The great vital and conservative element in our system, the thing that holds our system together, is the belief of our people in the pure doctrines and the divine truths of the Gospels of Jesus Christ." Now, this was from the Judiciary Committee. Now, the next is the Supreme Court ruling in Emerson versus the Board of Education. Now, this was the first time that part of Jefferson's letter was used. The First Amendment has erected a wall of separation between church and state. That wall must be kept high and impregnable. This was the first time that his letter was used out of context. Now, Dr. William James, father of modern psychology, quotes, "If you repeat it often enough, people will believe it." Now, the Supreme Court, after 1947, began to speak of a separation of church and state, saying, quote, "This is what the Founding Fathers wanted, separation of church and state. This is their great intent." Now, this is the Supreme Court, Bear versus Colmorgan, 1958. A dissenting judge warned that continuing talk about the separation of church and state would make people think that it was part of the Constitution. Imagine that. The following is from June 25th, 1962. Engel versus Vitale. Supreme Court struck down school prayer. For 170 years before this case, the court defined church as being a federally established denomination. The turning point. The 1962 case redefined church to mean any religious activity performed in public. It will now prohibit religious activity in public settings, and is not from the Founding Fathers. Now, this was the first case in Supreme Court history to use no precedents. It did not quote any previous legal cases or historical incidents. How about that, huh? Within 2 months, they also prohibited Bible readings from schools. Now, in June 17th, 1963, Abington versus Shemp and Murray versus Corlett. Number one, it reaffirmed the ban on school prayer, and number two, it banned school Bible reading, which was used for many years in schools. And then it got to the point in court, and I quote, where they said if portions of the New Testament were read without explanation, they could be and had been psychologically harmful to the child. This was yet another example of lacking both historical and legal precedent. 1967, DeKalb versus Despain. The court declared a 4-line nursery rhyme unconstitutional, and it was used by a kindergarten class. The reason? Although the word God was not mentioned, if someone were to hear the rhyme, he might think it was talking about God. That's pretty good, huh? On the Ten Commandments. Stowe versus Graham, 1980. If the posted copies of the Ten Commandments are to have any effect at all, it will be to induce the school children to read, meditate upon, perhaps to venerate and obey the commandments. Ooh, that's bad. And they further went on to say, which is not permissible or objective. What? Thou shalt not kill, thou shalt not steal is not constitutional. The court was inferring that our founding fathers would object to this. Well, yeah, right. Give me a break, will you? James Wilson, a signer of the Constitution, said, human law must rest its authority ultimately upon the authority of that law which is divine. Far from being rivals or enemies, religion and law are twin sisters. Indeed, these two sciences run into each other. The divine law form an essential part of both. How's that, huh? Okay, now we go on to the unconstitutional prayer. It goes as follows, and I quote, Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessing upon us, our parents, our teachers, and our country. All because it mentioned God once, it was deemed unconstitutional. While the Declaration of Independence uses the word God 4 times. Will you give me a break? Now 1962 Supreme Court reported that only 3% of the nation did not believe in religion or God. The unconstitutional prayer was consistent with the beliefs of 97% of the country. Yet the Supreme Court sided with 3%. It was the first time that 3% over 97% became a majority. Think about that. Separation of church and state started in this country. Does it make sense to you how this whole thing started? I know it doesn't make sense to me, and it pisses me off. So there you have it, how that they were able to get away with it. What I'd like to know is, what was the majority in this court? Was it liberal or was it conservative? I'm going to look into that. I'm curious to see exactly where the balance was there in 1962. I think I'll check on that. I hope you enjoyed this. It was pretty cool. I didn't know all this information, and I hope you liked it. Thanks.